welcome to today's video. Today I would like to give you a very brief introduction of the changes of Global Talent Independent Program. In fact, that the legislative amendment was published last Thursday. So this amendment not just applicable to Global Talent Independent Program, but to other visa subclass as well. But something that's really highly relevant to Global Talent Independent, which I'll be introducing here. So first of all, we have a change that the Distinguished Talent Visa, which is operate currently under this Global Talent Independent Visa, that the subclass 1 to 4 has been removed. Okay, illegal definitions omitted, which is being removed. Now we will no longer have subclass 1 to 4, but we will have A58. Subclass A58 covers onshore application and offshore application, meaning that it will be no two subclasses. We will only one subclass. So that change is significant because in previous cases where if you launch offshore application, all the dependent or everybody need to be offshore in order to grant visa. But if you onshore application, that if your family member, for example, wife kids, they're outside Australia, you have to enter Australia in order to be grant same visa. This was the previous case. Now because of change, that will be no longer the case. The new subclass A58 will allow everybody to grant same visa regardless where they were at the time of visa application and where they are now at the time of decision. So which means if you lodge a visa application while you are in Australia but kids they are outside Australia, you can be granted at the same time without them to enter again. Okay, so you can be all approved the same visa at the same time under the same class A58. Now this is only applicable to some visa applications that's lodged but hasn't made decision. All right, hasn't made decision. If your application pending now, in this situation, probably some of candidates that they already book a ticket say, oh, you must enter now. No, you can cancel ticket now because visa subclass will be granted. It doesn't matter where they are now, you'll be granted same time. So this is first change. Okay, so first change is we will no longer have subclass 1 to 4. We will have A58 cover all onshore, offshore applications. Okay, so which means it's beneficial, right? Beneficial because you don't need to wait. A visa can be granted regardless where they are now, regardless when you launch an application, right? So this is applicable to applications that is pending. The first introduction, first change. The other change is form itself, right? Form itself. Previously for 1 to 4 or A52, A58, there's no requirement you must complete nominator information, right? You must complete nomination information. Now in previous cases, you just the form itself doesn't require you to complete nominator, so you just go to the end and then you upload a nominator's document. So form 1000, supporting statement, evidence showing that nominator status. So in this case, previously that's the case. Now department now introduce new form where require you to complete the nominator information. Otherwise, you cannot proceed. I think this is good. Why? Because I believe that will be some cases where application just lodged without nomination information. They thought, you know what? I am going to try. Okay, I'm going to try, put on random number and see whether I can go through. So this is not good, right? It's not good practice because you need to make sure at the time of application, you do need a nominator which is already met requirement. Okay, so I think this introduction is good as well because it ensures every application when they lodge, they have the sufficient information. They could not just lodge and they find out later on they could not meet nomination requirement, the visa will be refused, right? So bear in mind when you lodge the actual application, whether it's pending, whether it's already lodged or whether you are about to lodge, you must have nominator's information beforehand. Okay, now of course, or the first stage you also need requirement, but sometimes talent officer they still grant and give out invitations. They do not check or they did not check the details of nomenclators, and you got nomenclature approval, and then you thought, oh wow, you know, probably my nomenclature will meet the requirement. No, you need to check it again on the final stage, because final stage is actually the decision maker. So this is a good one, allows you to complete form, complete nomenclators information before you can proceed, to ensure that all applications has, you know, can go through at the end. So I think the department wants to increase that, the successful rate. Now, third change is really important. I think it's beneficial as well. That new subclass A58 has removed the public interest criteria for 005. Okay, and then replaced by public interest interest criteria for 007. Okay, the difference too is significant, really important. And I think we have one pending application where initially I told them, no, you could not meet 4005 requirement, because 405 requirement does not have waiver clause. This is really important. Now, if there's some kind of you have some kind of health condition, that if your cost in the next 10 years exceed to 49,000, that you cannot meet health requirement, and the visa will be refused. Regardless, the dependent family member is currently migrating member or non-migrating member, because all of family members, even they are not migrating now. So for example, if your wife has kind of health condition, even she does not migrate now, the department will still ask her to do health exam. Now in the previous case, because 4005 does not have has the waiver clause, if you don't meet that, they will use the worst scenario calculation. If you don't meet that, then there's no waiver. There's no discretion, right? Fail. So one fail or fail criteria. One applicant fail the health exam, the whole application will not go succeed. So, but because of new introduction of the 4007, it has one special clause, which now visa applicant or dependent, whoever has health condition, has a waiver clause. Now, if that is a waiver situation, now because of that, waiver means you have room to put your case together, to explain to the department about the actual situation. For example, health condition will be analyzed depending on the applicant's actual health, diet, family history, or actual cost when they are in Australia, or the current cost, right? So all the consideration will be put on the table for a discretion. I think this is good news as well, because if you previously have any problem with, for example, being advised you're not able to meet health criteria, now you have a chance to look at it again to see, oh, maybe you're able to meet 4007 because it has a waiver clause. Okay, so overall I summarized 3 major changes with the new legislative amendment. First change is that you need to it doesn't matter whether you are in Australia or outside Australia. It doesn't matter whether family members are outside in Australia. The visa will be granted at the same time. So if even your application is now pending, previously you probably submit subclass 1 to 4, but because you haven't finalized, now the subclass will change automatically to A58. So if you book a flight ticket, just try to meet the offshore criteria. You can cancel now, okay? You can cancel. Of course, you want to enter, that's no problem. But if the booking flight is for the purpose to meet offshore criteria, you don't need to worry about it. Your visa will be granted at the same time. And if you're not sure about that, you can actually contact the decision maker, say, please confirm if this is a situation. According to the law, yes, it is a situation. The second change of the form, it's actual form. The actual form is we no longer have 1 to 4 subclass, but we will have A58 across the board. And A58 subclass will require you to complete nomenclature information before you proceed. Okay, and this is the second change. The third change is that we have changed this public interest criteria, where you no longer have public interest criteria 4005. Instead, it has a 4007, and 4007 has a waiver clause. If in the previous case you were no longer able to meet, you were not able to meet the 4005, you might be able to meet now, which means you might be able to grant a visa now. Okay, so if your application is pending on the health situation now, and you don't know, you need a waiver or not. If you're my clients, of course, I will have to already told you that you can contact me about that. If you are worried about that, you can contact us. Now, overall, what's my feeling? Often I talk about this. So what is my interpretation every time this policy change? I have my own interpretation, and my strategy towards that change is quite different. Now, as I mentioned in all my videos, so this is Global Talent Visa will receive mandatory review in April 2023, okay? So that is a mandatory. Now, nobody knows in between that whether the policy will change, which will change using the legislative amendment to change it. Now, the change itself, I read it in a way of a positive change, because it allows you, and which is I already read this explanatory statement, which is, 100 pages of that. It gives really detail of explanation what they want to do, why they change in the way. I think this is actually encourage candidates to apply, saying, which means that Global Talent Independent, one is very successful, awesome, and congratulations for all applicant approach has got your results ready already in your pocket. It's really good for us. So the current change, I interpret in a way, is very positive change, which means they really want someone who's really, really good candidates to approach and to get to be invited for this program. Now, because of the change, it doesn't mean that the requirement, the bar is actually lower. The bar is actually, recent our assessment is ahead, it's been increased a lot. So previous case, for example, I will just clearly say that if candidate they approve Global Talent Independent Visa in April, the same candidate, will they be approved same visa now? I doubt, okay, because we have been experiencing all the way around. I can see that the requirement for visa applicants, it's actually increased. But the requirement for nominator actually decreased. But there is a combination of two, really combination of two. So if you ask questions, will department have any other change in the near future before the 2023, April 2023? I would say definitely, right? Definitely, because it's subject to change. You are eligible for now, it doesn't mean you're eligible for the future, because it is not the law itself, the criteria itself change, but interpretation change. That's how I interpret the way. Now, obviously that this is the reason when I give offer, my offer is only valid for 1 month, because I could not predict and I could not guarantee if you come out 6 months later, are you still be okay? I have no idea of that. The immigration law changed all the time. So, okay, thank you very much for watching. Remember, if you have any questions, you can send an email to us or comment below and I will get back to you. Thank you for watching. Bye-bye.